Welcome back to Court TV Live. I'm Julia Janae.
And I'm Michael Ayala. When we begin this hour in Wisconsin, where a revocation of conditional release hearing got underway for Morgan Geyser. She's known for almost killing her 6th grade classmate in 2014 in the Slender Man stabbing case.
Yeah, Geyser was arrested last month after she cut off her GPS monitor, fled a group home, and that she was released to. This was following her release from a psychiatric hospital.
The 23-year-old was found outside of Chicago, with her 42-year-old transgender friend sleeping on the sidewalk of a truck stop. A moment caught on police body cam.
At this point, we're just done to 10.
Okay.
Please
let her go. Please let her go.
Then give me your name.
I did something wrong. She didn't.
What did you do?
She doesn't know what I did.
Okay, that's fine.
Let me talk to you over here. Okay, I'll put it back.
What is it that you did wrong?
I did something really wrong.
And what is your name? What's happening? We don't want problems with you, okay? We just need to ID you. That's it. What did you have wrong? What?
She doesn't know my real name.
Okay. Well, give him your real name. Don't tell him.
Okay.
What's your last name?
He says you just can't give me the information.
Okay, so it's Morgan.
Morgan.
And then your last name?
Geyser.
G-U... What is it?
Geyser. I promise she did not know.
G-E-Y-S...
ER.
And then what's your date of birth?
May 16th, 2002.
Okay. So Morgan is your first name, right?
Yes.
G-E-Y-S-E-R?
No.
Let me say goodbye, please.
Okay, we will.
I will never see her again.
Yeah, you will.
No, I won't.
3014. Can you take a name and date of
I did
birth?
something bad. Let me say goodbye.
Now, that was after she had given initially a fake name to the authorities. The State Department of Health Services filed a petition on November 25th seeking to revoke her release, and she has recently decided not to contest that revocation of her release privileges.
All right, before we get into today's hearing, here's more on the case against Morgan Geyser.
I just want to let Ella and her family know I'm sorry. Never meant this to happen.
That is Morgan Geyser at her sentencing hearing after pleading guilty to a brutal stabbing that left her friend clinging to life. Geyser and another girl, Anissa Wire, stabbed fellow 6th grader Peyton Bella Lutner after a sleepover at Geyser's home. The girls claim they carried out the attack over their belief in a fictional internet horror character named Slender Man.
I believed that if I didn't go through with it, Slender Man would come and attack and kill myself, my friends, and my family.
Wire pleaded guilty to being a party to 2nd-degree homicide, while Geyser pleaded guilty to attempted 1st-degree intentional homicide. Both girls were deemed not responsible for their actions because of mental illness and ordered to serve their sentences at mental health facilities. At separate plea hearings, the girls described what happened as they led their friend into the Waukesha, Wisconsin woods on that spring day in 2014.
Morgan asked me whether or not she should do it, and I just wanted it to be over with, so I said, just go berserk, do what you have to do.
I came up from behind her. I jumped on her. I tackled her. And I stabbed her.
Do you know how many times you did it? 19.
Their victim, 12-year-old Peyton Lutner, lay bleeding with her friends standing over her.
Anissa told her to lie down so she wouldn't lose blood so quickly and told her to be quiet, and we left.
So much has been made of Morgan Geyser's mental state. So we're going to get you inside of the courtroom where that revocation of conditional release hearing happened today.
The bill number 2014 CF 596, State of Wisconsin versus Morgan Geyser. Can I have appearances, please?
Abby Nikolai appears on behalf of the state. Good morning, Judge.
Good morning, Judge. Morgan Geyser and Attorney Anthony Cotton both appear by Zoom from separate locations.
And good morning. We also have a DHS representative on the line. We are here to discuss the petition for revocation for conditional release that was filed on November 25th. And in particular, Ms. Geyser's stated intention not to contest the petition for revocation of conditional release and waive the evidentiary hearing on same. Just as a matter of what I think is undisputed, Mr. Cotton, there's no dispute the petition to revoke was timely filed under the statutes. Is that right?
Correct, Judge. No dispute.
All right. And by way of background, just to catch us up, Ms. Geyser was previously found not guilty by reason of mental disease or defect in October of 2017. In February of 2018, Judge Bourne sentenced Ms. Geyser through an order of commitment for 40 years. On January 9th of 2025, Judge Bourne deemed the conditional release was appropriate and entered an order that she be conditionally released. And while it took a while for the conditional release plan to be developed effectively, the actual conditional release plan was finalized in September of this year. And after certain events occurred, the DHS filed a petition to revoke Ms. Geyser's conditional release on November 25th of 2025, and that's what brings us here. In that petition, the DHS alleged that revocation of Ms. Geyser's conditional release is appropriate under WISTAT section 971.173E, and the state contends that both the conditions of Ms. Geyser's conditional release were violated, and that remaining on conditional release would pose a risk both to her own safety as well as the safety of the community. The allegations include, and I won't go through them all, that Ms. Geyser fled placement, cut off her GPS monitor, and committed other violations of the conditional release order. In support of their petition, the state has alleged, the DHS has alleged, that Ms. Geyser violated the rules for conditional release, and under the circumstances, her release would involve a continued heightened level of dangerousness if she remained on conditional release, both to herself and for others. In my understanding now, based on Attorney Cotton's earlier correspondence, is that Ms. Geyser intends to waive any objection and will not be contesting the petition for conditional release. Is that right, Mr. Cotton?
That's right, Judge. I spoke with Ms. Geyser at length about this decision, and we don't intend to challenge the revocation.
Okay, thank you. I just have a few questions for Ms. Geyser just to make sure she's making this decision freely, intelligently, and voluntarily. And Ms. Geyser, you've had a chance to review the DHS position for revocation of conditional release?
Yes, sir.
Okay, and you've been able to review it with your counsel, and he's answered any questions you may have had about it?
Yes, sir.
And Ms. Geyser, you understand you're entitled to have an evidentiary hearing on the DHS position to revoke your conditional release?
Yes, sir.
And you understand if we had that hearing, it would be the state's burden of proof to show that the revocation of conditional release is appropriate. You understand that, ma'am?
Yes, sir.
And you further understand that the burden of proof the state would have to face is to prove that by clear and convincing evidence.
Yes, sir.
And your counsel, for you, waived the 30-day time limit for having that hearing on your behalf, but we currently have a hearing set for February 16th, 2026. You understand that, ma'am?
Yes, sir.
And if we had that revocation hearing, you understand you would have the right to be represented by counsel, is that correct?
Yes, sir.
You'd have the right to see and hear the evidence the state presents at that hearing, is that correct?
Yes, sir.
You understand you'd be able to present evidences and witnesses on your own behalf, is that correct, ma'am?
Yes, sir.
And you understand you'd also be able to cross-examine the state's witnesses, is that correct?
Yes, sir.
All right. And you've been satisfied with the services of Mr. Cotton, is that correct?
Yes, sir.
And earlier on December 16th, 2025, Attorney Cotton provided me with some correspondence indicating that you have elected not to contest the position to revoke your conditional release. And that's true, ma'am?
Yes, sir.
And you are satisfied that you've had ample time to discuss the ramifications of waiving that hearing and the burden of proof the state would have to face if we had that hearing, is that correct?
Yes, sir.
And your counsel is able to answer any questions you might have about the DHS petition for revocation of your conditional release, is that right? And at this time, is it your decision to waive the hearing on the petition for revocation of conditional release? And you've decided not to contest the merits of the petition for revocation of conditional release, is that right? And you understand that if you waive your right to a revocation hearing, ma'am, the court will revoke your conditional release and order you returned to inpatient commitment or other custody under section 971.17, okay, and the state will not have to prove any violations of the hearing, ma'am. You understand that? And you understand that revocation of your conditional release will result in your continued confinement under your NGI commitment, subject to further future review as provided by law. Is that correct? And again, you've had what you believe to be sufficient time to discuss this decision with Mr. Cotton. Is that right? And no one's promised you anything for waiving your right to contest the petition. Is that correct? And no one's threatened you to make you waive your right to contest the petition. Is that correct? And you're making this decision to waive the revocation hearing freely, intelligently, and voluntarily. Is that correct? Okay. And you understand, finally, by waiving that revocation hearing, you're giving up your right to contest the allegations in the state's request for revocation, correct? And knowing all these rights and consequences, do you knowingly, intelligently, and voluntarily waive your right to a revocation hearing under WSStat 971-17-3E? Thank you, ma'am. Do you have any questions at all for me regarding your decision? Ms. Nicolai, do you believe any additional colloquy is necessary?
No, thank you.
Based on my discussion with Ms. Geyser and her counsel, as well as my review of the relevant filings made by the DHS in connection with this petition to revoke conditional release and related filings, the court finds that Ms. Geyser has freely, intelligently, and voluntarily made the decision not to contest the DHS petition for revocation of conditional release and waives her right to a hearing on same. Accordingly, the court finds that the petition to revoke conditional release is meritorious, uncontested, and it is granted. The petition to revoke conditional release is granted, and Ms. Geyser is remanded into custody with directions to DHS to house her pursuant to the original commitment order that was in effect prior to the granting of conditional release.
All right, there you have it from the judge. Let's bring in our guest for this hour to discuss. Joining us from Sarasota, Florida, we have trial attorney Alexis Rosenberg, and from Atlanta, Georgia, trial attorney Dwight Williams. Thank you both for being on with us this Tuesday morning. We're hearing the term, Alexis, NGI over and over, not guilty by reason of insanity. That's what a jury convicted Morgan Geyser of. Can you talk about, we don't often see that here on Court TV, what happens to people after their NGI. Just react to what we're seeing inside of this courtroom.
Well, this was an unusual case to start with, but you are correct. Generally, we do not get a conviction with insanity. It's very difficult to have. So what we're seeing right now is she was sentenced to be placed into that mental health psychiatric facility and to be housed there. And then, as we know, there was a hearing where she was let out on, release, but it had certain constraints. For instance, she had to have the tracking device, and she had to be in this group type facility, and she left there. So they moved to revoke that. So what's going on now, what is interesting, is she waived her right to fight that. And that could have a lot to do with her mental health and where she is. She may feel that she's a danger to be out, even though it was found she wasn't.
Dwight, and I think that's exactly the case. I want to get your thoughts on the fact that she chose not to fight it. Again, her actions suggest that clearly she wasn't ready. A lot of us, when the hearing happened, felt like it might not be the right choice at the time, that she wasn't ready. She served 8 years. She had a total of 40, so she still has 32 remaining. I don't know how long she'll be in before the opportunity to come out comes up again. But your thoughts on her decision not to contest it this time?
Well, sometimes in the law, you have to bite the bullet. And this is a situation where the facts are what they are. I mean, she had a wonderful opportunity to reestablish herself, to go in this group home setting. She, for whatever reason, mentally, physically, emotionally, she decided to take off the monitoring, to escape. She likely spoke to her counsel, and counsel said, hey, there's probably only one outcome that's going to happen with this revocation hearing. So why not bite the bullet today, take your medicine, get back into a facility. And then what the court always likes, and what I appreciate, is the redemption story. How does she do in the years to come, so that perhaps she comes back at a certain point and perhaps she's given a second bite of the apple and is allowed to come back and have an opportunity that she did before. So I think it was a smart decision by her, and more importantly, her attorney.
Yeah, Alexis, her attorney, this put them, I feel like, in a very weird position because they argued very passionately to get her this release. And then for this to happen, they had to go publicly on Instagram and say, turn yourself in. I mean, that was quite a position for this attorney to be in. Can you talk about that? for this attorney, could that have played into not wanting to fight this at this stage and maybe even recognizing that she's not ready?
So, I mean, as attorneys, we don't always get, and a lot of times don't get, clients with the best circumstance. So as her attorney, he had to advocate for her. And in that particular moment, he was advocating for her release because that was what the client wanted. Now we have a situation where he's asking for her, like you said, to be returned, but it's not his decision. That is why the court went through all of this, that she waived on her own accord, that there wasn't pressure, that she made this decision, because it's not ultimately the attorney, although we can give advice in our recommendation, it's not our decision and our choice whether we're going to waive this type of thing. And that's why he made sure, the judge, to put all that on the record.
Yeah, and let's not forget, there were 3 doctors that testified to say that she was ready for this particular move. So again, he's covered as far as that